Meyer is next.
Thank you, Your Honor. Good morning, sir.
Good morning.
I'm going to ask you some questions. Start off with some of your direct testimony. If we could have that on the screen, please. And we'll start on page 3 of 6. And the answer portion to the question that began on line 15. Thank you. It appears, and tell me if I'm wrong, but you've your answer on to the question at line 15 tried to quantify the number of voluntary easements that have been signed, or the progress that has been made, and you've tried to quantify it in terms of the number of tracts or the percentage of parcels and miles, correct?
Yes.
Have the numbers been run on the actual number of landowners? Has there been an expression percentage-wise calculated what percentage of landowners of this 3,307 tracts or 685.5 miles have signed up?
It's within a percent of the tract percentage. Typically mileage, tracts, and landowners are all within a point or two of each other.
All right, so you think it's fairly similar. In your answer was 68% of the tracts and 69% of the miles. You think the number of landowners would essentially be, give or take, deviate a percent one way or the other?
That's right.
Okay. Now, if I could have page 2 of your direct testimony on the screen, please. And in your response to the question posed at line 17. It says, I'm testifying in support of Summit's proposed pipeline project regarding the permanent and temporary easements that Summit requires for the project, correct?
Yes.
And you've testified in these proceedings regarding some of the language in those easements, correct?
I have.
How did you gain your understanding of what that language meant to Summit?
How did I gain my understanding of what the easement language meant to Summit?
Well, let me ask you a preliminary question. Did you draw up those easements yourself?
I did not.
Do you know who did?
I believe those easements were generated in in collaboration with council, but they were generated prior to my arrival on the project.
Are they essentially a template?
Yes, there's a template easement. That was part of my testimony there.
Okay. So again, you're testifying about what the words mean, and how did you gain your understanding? Or are you just kind of winging it here?
Well, I'm certainly not winging it. I think the driver behind my understanding of easement terms comes with 15 years of land acquisition experience and management, along with thousands and thousands of easement documents. So certainly certainly not interested in winging anything. But my understanding of most of those terms is pretty basic because they're general terms. There are some portions of that easement, as I cited in my testimony, that involve a little bit more legal ease or legal opinion, such as indemnity or insurance. But in general, my understanding of the easement comes with my background and certainly the instructions I've received from the folks that I report to here at Summit.
All right. So, and I noticed in your answers, in your direct testimony, you've got 15 years of experience doing this sort of thing, correct?
That's right.
And you'd agree that in order for there to be a binding agreement, there needs to be a meeting of the minds, right?
A meeting of the minds?
Between the two parties?
I think there needs to be an agreement between the two parties, yes.
Okay. Do they disagree on what the agreement is and still have an agreement?
They may have preferences about things that are in there that they wish were different, but yes, there's an agreement there.
Okay.
I'm not sure I understand your question, but
well,
I think I do.
In your answers, you've used the pronoun I, you've used the pronoun we in describing the meaning of the language, what these easements mean. So when you say we, do you mean Summit?
That's right.
When you say I, do you mean Summit?
Yes.
Okay. Can we have Mr. Rorie's Direct Exhibit 1, please? Thank you. Sir, there's the prepare information. It says Jennifer Hodge Burkett. Is that right?
Yes.
Do you know who that person is?
That's an attorney that works for us.
And is that the address there, 111 East Grand Ave in Des Moines, where the attorney's office is?
I believe that's the case, yes.
Do you know or did Ms. Burkett prepare these easement agreements? Or these easements?
I believe she did. Or certainly in collaboration with other counsel. Maybe she was the leader of that effort.
Okay.
Again, they were generated prior to my arrival.
Do you know of any easement agreement that has been recorded that has some other preparer's information?
I don't believe there is one.
Okay. Can we have, is it pronounced DePima, Exhibit 4? Thank you. Can we look at, or scroll down to section 1A, please? All right. Oh, you went a little too far. Right there. Thank you. So 1A, where it says pipeline easement, you see where I'm at?
Yes, sir.
Okay. Now, just looking at that section 1A, the first sentence begins, a free and unobstructed, permanent, non-exclusive pipeline easement, 50 feet in width, and then parenthetically, in quotation marks, pipeline easement. You see where I'm at?
Yes.
And if you go down to the end of that section 1A, it talks, or it closes in a parenthetical, says collectively the, quote, pipeline facilities, quote, in parenthetical. You see where I'm at?
Yes.
So this section 1A, is it fair to say it's describing two things here, one being the pipeline easement and then the various pipeline facilities that are going to be, constructed or operated within the easement?
Yeah, the general appurtenances that are cited there in that paragraph, yes, that's what pipeline facilities covers.
And would it be fair to say that after the first parenthetical, 50 feet in width, pipeline easement, anything described after that is basically relating to the pipeline facilities?
I don't necessarily agree with that. There are references to the pipeline easement in our documents talking about reclamation of the pipeline easement. You wouldn't reclaim the pipeline facilities, so there's a difference there.
Well, and that's one of my points is throughout the document, there are distinctions, and the document carefully distinguishes between the pipeline easement and the pipeline facilities. Is that fair?
Sometimes it does, yeah.
Okay. And in this particular section, that's all I'm concerned about right here, is where in that section A does it start to identify what the pipeline facilities are? Can you point that out for us?
Looks like whenever it would be talking about the pipeline, including the pertinent facilities. Talks about the pipeline not to exceed a certain diameter, and then continues on talking about the product.
Okay, so would it be fair where you see where it says basically right in the middle there, abandoning in place or removing at will, if in whole or in part, comma, would you agree that after that comma, after the word part, this next parenthetical or the next phrase, one pipeline not to exceed 24 inches. Anything after that is referring to the pipeline facilities. Is that what I understand you to say?
Abandoning in place, I think, would apply to the pipeline facilities. Maybe a better question for council is the semantics there, but I think the goal here is to define that there's a pipeline and there's related facilities tied to it to encapsulate both of those.
All right. Well, is it your understanding that an easement creates an interest in land?
Yes.
Okay. And the land is defined, the pipeline easement in this section 1A is defined as a 50-foot wide piece of land, correct?
Yes.
Okay. If we kind of scroll down a little bit under temporary easement, the last few words there where it says, in part, the pipeline facilities in the pipeline easement.
Yes.
In the pipeline easement. Again, that's a distinction between the facilities and the easement, correct?
Yeah, I think it's saying the pipeline facilities are inside the pipeline easement.
Okay, right. So there's a distinction being drawn there between those two things, right?
I suppose.
Well, I don't want you to suppose. I mean, it's your document. It's Summit's document.
I can give you better if you ask a question different, but I suppose if I understand your question correctly, the pipeline facilities would be within the boundaries of the pipeline easement. That would be the case.
The word in is kind of critical there, isn't it? There's something within something else.
Yes.
There's facilities within an easement, correct?
There are.
And the easement is the land.
Yes.
Okay. And if you could scroll down to section C, there you are. You're already there. Good job. Right in the middle there, after the parenthetical that has access easement in parentheses, for the purpose of ingress and egress to the pipeline easement. You see where I'm at?
I do.
Again, that would tend to connote that the easement is a piece of land. It's real estate. Correct?
It's limited surface rights to ground, yes.
Okay. If we could scroll down to section 5A, I think it's on starts on the bottom of page 3, I believe. There we go. In section 5A, the last sentence, the use of the pipeline easement by the landowner shall be regulated by all appropriate ordinances, regulations, resolutions, or laws of the governmental entity with authority over the pipeline easement. Is that right? I read that correctly?
I believe you did, yeah.
Okay. And again, the pipeline easement means land.
Yes.
So is it Summit's intent, its meaning, its understanding of this language to mean that the landowner is that land, the easement, the ground that the landowner owns is still subject to ordinances, regulations, resolutions, or laws of the governmental entity with authority over that land?
I think appropriate is in there as well, to the extent that they're applicable and enforceable. I think what you're saying is right.
Well, that land, let's assume that land, the landowner's land, was already, prior to this agreement, subject to county ordinances, various permitting requirements of the county. You're basically saying the landowner is still bound by those things, right?
I think this is referencing the pipeline easement, not what the landowner was bound to prior to the easement being present. It cites the pipeline easement at the beginning of the sentence.
So are you saying that this agreement relinquishes the landowner of all obligations owed under any local rules or permits?
Objection. Calls for a legal conclusion.
Your Honor, it doesn't. I'm asking for his interpretation and his understanding of what Summit's intent is. That's all.
Can you restate the question?
Can you have it read back, please?
Thank you.
So are you saying that this agreement relinquishes the landowner of all obligations owed under any local rules or permits?
Same objection.
I'll rephrase, Your Honor.
Thank you.
Sir, is it Summit's intent, in meaning, by using this language, that the landowner is no longer obliged to follow local ordinances or permit requirements for that land?
No, I think the intent of this sentence is talking about the pipeline easement.
And that's the land.
It's the land with the pipeline easement on it. I'm not speaking to, I don't think it has anything to do with what the land was subject to prior to the easement being there. There are several examples as to why this is applicable, one being the one call 811 requirement per statute in Iowa, but there are other resolutions of law that would apply to the last two words in that sentence, which is the pipeline easement. We're not talking about landowner's obligation prior to it.
Well, let me ask you about this then. In this 50-foot wide strip, when it butts up to a county road, could the landowner put a driveway to the road without getting county permits?
I could speak for the county. I don't work for them. But
if there's a requirement that the landowner would have to, is Summit intending to relieve the landowner of that burden?
To relieve the landowner of the burden of needing to get a road approach permit across the easement? Is that your question?
On that 50-foot piece of land.
Is it our intent to relieve them? I don't think so. I think we're talking about ordinances and regulations related to the pipeline easement, not what the county would require a landowner to do for a road approach.
Well, you're obliging the landowner here to still comply with appropriate ordinances and regulations. Would it be Summit's intent in understanding that it's referring to, for example, county ordinances that would require a permit to be obtained to put in a drive through a right-of-way drainage ditch?
I'm not sure. Was that a question? Help me here. If you could restate that, that'll help me.
Let's just assume some information here. Let's say there's an ordinance that requires, if a landowner wants to build a drive from their field to a county road right-of-way, mm-hmm. and the county has required them to get a permit. We're kind of playing dodge the head here, so I'm sorry about that. But
thanks for clarifying, sir.
If that requirement existed prior to entering this easement, is it Summit's intention that the landowner has to still comply with that or not?
I think so, that they would, whatever rules they need to follow to get a road approach. I don't know that we're affecting those or asking them to do anything different.
Okay. And when you obtain this easement, is it Summit's intention to obtain any more rights than the landowner has to grant?
Any more rights than the landowner has to grant?
Correct.
I think we're seeking limited surface rights for a non-exclusive pipeline easement and the related facilities access when appropriate or accordingly. I don't know that they can grant us anything that they can't grant us, but that may be a legal conclusion there in terms of what may be in play.
Well, I'm just asking if it was Summit's intent that they were going to obtain more than could be granted.
More than what could be granted via this document? No, not my understanding.
Okay. Is it did you know that who's Bill Sullivan? Do you know Bill Sullivan?
It doesn't ring a bell.
From Key Logistics. Do you know those folks?
Key Logistics?
Yes. Turnkey?
Turnkey, I recognize that.
Okay. But you've never heard of Bill Sullivan or William Sullivan?
I don't manage Bill. I don't manage Turnkey. It's not a part of my scope.
Okay. Well, what's your understanding of what Turnkey does?
My understanding of what Turnkey does is work to procure all of the non-environmental permits on the project, meaning road crossings, encroachments, road approaches, temporary crossing agreements, etc.
Okay.
Things of that nature is my understanding.
And do you have any knowledge as to whether or not, well, let me just ask you this way. Did you know that Turnkey has submitted various permit applications to Hardin County to, for example, build drives to allow ingress and egress to the land easement? Did you know that?
I don't know what they've done in Hardin County. I know they've submitted a number of permits, but
did you know
the specifics of those, I don't know.
All right. Did you know that they've also submitted permit applications to cross and enter and cross over the drainage pipelines in the drainage districts that will be affected by the project in Hardin County?
That sounds right to me. I don't know what they're doing in Hardin County. Again, I don't manage them at all in any aspect, so I don't look at their reports and know what they're up to.
And I'll ask another question just in hopes that maybe it would ring a bell. Do you know that Turnkey has submitted permit applications to build above ground facilities related to this project?
I think if that was an applicable part of a permit, I'm sure that they would be dealing with that. I just don't know the specifics of whether they've had to or if they've initiated that effort.
Okay. Would you agree, though, that if those things have taken place and given your testimony, your understanding of what the language in 5A or Section 5 that we've talked about, that would be consistent, those activities by Turnkey would be consistent with your testimony today? That those permits aren't environmental in nature and therefore Summit needs to obtain them?
It's a function of a pipeline project to obtain non-environmental permits, yes.
Okay. I'm not sure where in this particular exhibit the language is about basically decommissioning or removing the pipeline, but there's language in these easements that speak to that, correct?
I mean, there's general mentioning of abandoning, and if that's what you're referring to.
Yes.
Decommissioning and abandoning the pipeline.
All right, and you're aware that the Iowa Code under 479B, subsection 32, does require removal?
I don't have the subsection memorized. My understanding of the rules is that by default, the pipeline could be abandoned in place as long as it's done under certain regulations, but the landowner has the discretion to request that the pipeline and its related facilities be removed.
All right, so do you know, have the numbers been run in the event that 100% of the landowners were to seek removal? Do you know if those numbers, the cost of that, has that been run within Summit?
Not to my knowledge.
But Summit's obliged to do that and bear that cost, or whoever might stand, if it's the successors of Summit Carbon Solutions would still have that obligation, correct?
I think it depends on if there was something individually worked out with the landowner. I don't, if the landowner said, under no circumstances do I ever want it removed, I think that we would have to look at that compared to what the rules say and see which one of those controls. But I think that in general, if, as a company, if the landowner is elected to have the pipeline removed upon abandonment, then we're typically okay with that.
Well, I get that. All the landowners could just say, we love it, leave it. But you're saying that Summit hasn't, you're not aware that they've run the numbers. They don't put this down as a zero cost to them, do they?
I have no idea. I don't know how applicable those numbers would be. Given the cost of what that would be completely different at the time of where we were running the numbers. But I have nothing to do with forecasting hypotheticals decades or centuries from now. I have no idea.
And that's a problem for the landowners too, isn't it?
What is a problem?
If they want it removed, but nobody's calculated or planned for those costs, how is it going to happen?
Well, the landowner's not paying for the cost. I don't know it's a problem for them.
But they want it out. Well, sir, they want it out. And whoever has that burden on your end of the stick doesn't have the money to do it. There's bankruptcy in the future. What happens to that pipeline? It stays in the ground, doesn't it?
I don't agree there. I think that if the pipeline system were abandoned and we were obligated by law to remove it upon the landowner's request, then we would.
How does a bankrupt company do that?
Venturing into things I have no experience with. I've never worked for a bankrupt company. I also don't deal with a whole lot of abandoned pipelines. So just asking something outside, I'd like to finish if I could. You're asking something outside of my scope.
When you're in your experience with these over the 15 years that you've been doing this, have they all these years been with Summit, or have they been with other outfits?
Other companies.
Okay, and whether it's been Summit or other outfits, has there ever been any kind of a reserve? Are you aware of any reserve that's been held in the event that these need to be removed?
I don't know how the dollars were held, or if reserve is the right way to do it, or what to call it. In the unlikely event that a portion of a pipeline was abandoned, it was not an issue. We pulled it up if we needed to pull it up. Again, very rare situation, unless for some reason that particular part of a pipeline system was no longer in use or anticipated to be in use. So it's not common to abandon them and pull them up.
Do you know whether Summit has obtained or attempted to obtain, other than permits from drainage districts, any easements from drainage districts?
I really don't know.
Do these easement agreements, would they allow Summit to put a well on within the easement?
A well?
A well,
Like a water well, or?
yes.
Not to my knowledge. I can't imagine a scenario in which we would need a water well.
Well, that's going to be my next question. For what purpose would you need a well?
I mean,
Is water part of this process, to your knowledge?
it's not common for a pipeline company to drill a water well unless it's tied to some water well we're replacing or something like that.
At the point where, let's say like an ethanol plant, this point of conversion where it's captured before it's sent into the pipe, is there any water needed for that? Is there water part of that process?
Your guess is as good as mine. I don't deal with the inner workings of the carbon capture project process or the compression process. I imagine, if tying back to your question, the best I can, if we needed to drill a water well on the landowner's property for some unforeseen, extremely rare reason, we would need to seek additional permission to do that.
Okay. I don't have any other questions. Thank you.
Thank you. Mr. Taylor, I believe you're up.
Thank you. I'm Wally Taylor. I represent the Sierra Club. Are you aware that this whole process started about 2 years ago with what they called informational meetings?
I am.
Did you attend any of those?
I did not attend those. I was not present at Summit at the time.
Okay. But do you understand, though, that at those meetings, Summit made a presentation about the project and extolling its virtues and so on, and that the board representative who was there explained the board procedure? Is that your understanding?
It's my cursory understanding of them, yes.
And do you know that during that meeting, the landowners who were there were told that at the end of the meeting, immediately at the end of the meeting, before they even left the building, that there were land agents there to negotiate easements with them?
Objection. State your objection. Calls for speculation. The witness has just testified he wasn't at any of those meetings and not with Summit at the time.
Okay, thank you. Mr. Taylor?
I asked if he understood that, or if that was his understanding.
Can answer if you may. I have no idea.
Can you bring up Sierra Club Hearing Exhibit 11? You can move it up a little bit so we can maybe get the whole thing in. There you go. Were you aware that former Governor Terry Branstad sent this letter attacking Sierra Club to landowners along the Summit Pipeline route on December 10th, 2021?
I'm not aware of this letter, and I really am not aware whether or not it's attacking anybody. It's pretty blurry, and I haven't read it, but I certainly am not aware of it. September 2021, I was not with the company.
Is that the kind of thing that you would anticipate might be sent in order to persuade landowners to sign easements?
Could you unpack for me what you mean by type of thing? I'm not sure I can agree or disagree there.
Well, it's kind of hard to read up there, isn't it?
It's tough.
Let me read some portions to you. Second paragraph. Groups like the Sierra Club don't like ethanol. In fact, they don't like any liquid fuels and would be happy to ban all combustion engines. The Sierra Club is attempting to obstruct the bigger boost to ethanol in decades. The Summit Carbon Pipeline Sequestration Project. That on down the ways, in truth, if the Sierra Club gets its way, there will be nothing left of Iowa's ethanol industry. It would be out of business. Imagine what would happen to the price of corn and to the value of your land. It would be devastating. As a landowner and potential partner of the Summit Carbon Solutions Project, you are now a target of the Sierra Club. In the weeks and months to come, you will likely hear from them, making wild claims about the pipeline and encouraging you to oppose it. Please don't be intimidated. So is that the kind of language in a letter that would be sent, do you believe, to persuade landowners to sign easements?
I have to believe that that's a valid letter signed by Mr. Branstad, which I don't know that to be the case, but it looks like it is. Those are his words and information he wished to share with landowners along the route. It's hard for me to generalize as to whether this is the type of letter that would be sent to landowners, and to put it the way you phrase it, to pressure people into easements. I think this is more of an awareness letter, and was Mr. Branstad's prerogative to send that. He felt it to be necessary, if in fact he did. But I don't know how to answer your question about whether Summit would send this type of, as you phrased it, thing to landowners to pressure them into anything. I think we try to keep people informed and give them a heads up of what type of misinformation may be out there, which there's plenty of it. We try to at least have a seat at the table for a discussion about that misinformation. Mailings may be a way of doing that. But beyond that, it's hard for me to speculate as to what would and wouldn't be sent.
For the record, I said persuade, not pressure.
Okay. I stand corrected.
But from the letterhead, would you agree this was sent on behalf of Summit Carbon Solutions?
I have to believe that's our letterhead. Again, Mr. Taylor, I was a long ways away whenever this was written, and so I really don't know.
Thank you. So we would offer a Sierra Club hearing Exhibit 11.
No objection. Seeing no objection, the board will admit Sierra Club hearing Exhibit 11.
And then about a year ago, are you aware that Summit hosted, I think, 6 meetings around the state in the areas around the pipeline route, and served nice lunches and suppers to landowners to try to, again, persuade them into signing easements?
I don't know if the purpose of those, well, one, I don't know if there were 6 of them. I'll take your word for it. I don't know if it was lunch or supper either, but I understand the nature of what you're getting at. I don't think that those were in an effort to solely get people to sign easements. I think those were informational, community outreach types of efforts, but I could be wrong. But I certainly didn't organize, and I run all of our land acquisition. I didn't organize any lunches or suppers, specifically in an organized fashion to go around the state and try to get people to sign easements at those lunches. I didn't do that, but I imagine it's probably more of a community outreach effort.
So why was the land agents there?
They're the front end spearhead of our community outreach. We have a few people at the company that deal with some vendors that do community outreach. And then at the height of this effort, I had 200 plus people in the field. So we're the ones having a dialogue with landowners and people in those surrounding communities. So it's a symbiotic relationship there.
But isn't it the job of the landowners to get people to sign easements?
Is it the job of the landowners to get them to sign?
No, land agents, I'm sorry.
It's part of their job, yes.
In testimony last week, you said if a landowner says they don't want to sign an easement, the land agents or some representatives keep contacting the landowner. Why doesn't no mean no?
Well, as I spoke about last week, sometimes no has some motives behind it or some reasons, and we try to find out those reasons. So perhaps the landowners heard some wrong information about our project. Perhaps we've been villainized by people that don't have all of the facts. Perhaps they feel like, as some of the scenarios that were presented us last week, that we could change the product of the pipeline, or that it can combust, or that it's unsafe. So there's a number of reasons why a landowner would say, no, I'm not really interested in this. So to answer your question, no meaning no, we look at it as no meaning, okay, do you mind telling us why? And what we offer at the end of that conversation, if the landowner is still opposed or not interested, is to keep them updated on the progress. So much of this, as I stated last week, has to do with the evolution of this project gaining leaps and bounds in terms of public acceptance. We've got well over 1,000 landowners, over 1,200 of them that have reached an agreement with us. We have over 2,400 parcels acquired. That's over 500 miles of right-of-way. So as things progress, that notion changes. But if the landowner's not aware that things have progressed, we try to keep them up to speed on that. So that has been a very fruitful effort on our part. We continue to do that, and I think by and large, the landowners certainly that are having a dialogue with us at all appreciate being kept abreast of how things are going.
Do you think maybe at some point they feel like you've just worn them down and they're just going to sign an easement?
So I understand your question. I find it almost insulting to an Iowa landowner to think that would happen. This is their ground. No one's disputing that. They're extremely educated about their ground. They're mindful people. We enjoy meeting with all of the folks in Iowa to the extent that we can. I think it discredits the resolve of an Iowa landowner to think that they could be worn down. But I can tell you, as far as our approach to this, a concept that would even somewhat relate to that question has never come up. We don't approach this as wearing anybody down. We approach this as critical infrastructure to be installed, and we want to talk to folks about an easement on their ground. No, I don't see any scenario in which someone has thrown up their hands and said, fine, I'll just let an easement out here.
Do you recall during the first couple of weeks of testimony when the landowners were testifying, there was a Mr. Cons who said that he didn't want the pipeline, he didn't want to sign an easement, but felt he had no choice. Do you remember that?
I don't remember that specific man's name, so I'll take your word for that. I remember that topic being brought up. I also remember that he hasn't signed an easement.
That's right, but he was negotiating, didn't want to. Remember?
That's a part of any type of land acquisition project. I'm not saying that. I think we're jumping into two things: wearing somebody's resolve down and overwhelming them until they reach an agreement with us, is the way I think you presented it. Working through a negotiation that most people would prefer to not have is different, very different. One involves taking advantage of people and wearing them down. The other involves the necessary uncomfortability of the installation of infrastructure, I think, in almost any case. So I just want to distinguish between the two things there.
So if a landowner does not want the pipeline on his or her land, you would keep trying to get them to sign an easement, correct?
Certainly try to keep a dialogue open with them so that they were informed, in hopes of having continued conversations with them and eventually reaching an agreement. Yes. The fact that someone says, really not interested, that's not really an option for me to walk away from the good faith requirements of trying to acquire that easement.
Last week you said that you would expect more easements to be signed after the board issues a permit. So in other words, at that point, when eminent domain is really staring them in the face, you're saying that they would, at that point, sign easements because they had no other choice, correct?
That is not what I'm saying. But I was talking about there, I don't have the record in front of me, but what I was talking about there is some folks are perfectly fine with the benefits associated with this project. They understand the viability of it. They understand how critical it is. They would simply just prefer that we had a permit, and then they would execute an easement with us. So,
Pardon me, that makes no sense at all.
I believe it makes perfect sense, but I can unpack it for you. So if you're a farmer and you're selling to an ethanol plant, and I'm asking to encumber your ground with an easement, you may not want to go through the process of encumbering your ground just to have to find a way to get that easement released if we don't get a permit or ever build the pipeline. So that makes perfect sense. That why go through it unless it's a viable deal with a permit? So again, we're talking about a minority of landowners, a subset of the minority of landowners. That's what I was referencing to. The majority of landowners have reached an agreement with us, obviously prior to a permit, which is unprecedented, by the way. 500 miles of right-of-way in Iowa prior to a permit being received. It borderline screams of the acceptance of this project. But 26% of the mileage remaining, I would say a subset of that, as I cited last week, is simply waiting to see if the permit is viable, and then they'll go through working terms on an easement. So perhaps it doesn't make sense to you or the Sierra Club, but in the world that I live in on a daily basis, it makes perfect sense. It's a very natural thing. Any pipeline that requires a permit, there is a subset of landowners that are simply waiting on that permit to happen. It has nothing to do with their opposition to the project.
But it has something to do with eminent domain, doesn't it?
I don't think so. I mean, I think at the end of the day, eminent domain is an unfortunate circumstance, but certainly a necessary function for the installation of something this large. We certainly can't have a minority of landowners holding up or stopping or canceling the installation of something this critical and this large. So you have to look at majority and minority there. But I think if I'm answering your question correctly, the idea that everyone that hasn't signed to this point is going to sign simply because eminent domain is in play is very much incorrect.
Last week, Mr. Dublinsky mentioned that you were in a mediation. Was that with a landowner?
It was.
And who was in... How we phrase that? Without mentioning any names, what Who was involved in that? I mean, you and a landowner, I assume,
Yes.
and a mediator.
Yes.
Anybody else?
No. No. There's two parties and a mediator.
Okay. And is that one of the mediations that the board suggested the landowners could engage in?
That's right.
Okay. And how many of those have you done? Or has Summit done?
I need to probably get some advice on how much I can talk about that. The mediator has told me specifically that the progress, the volume, the contents of those mediations are strictly confidential as instructed by the board. You're welcome to ask the board if I can talk about that, but I need to follow the rules I've been told.
I wasn't asking the content, I just wanted to know how many mediations you'd had.
How many is content? I would ask you to ask the board if I can answer that question. If they feel like I should, then I absolutely will. But I don't want to break rules here.
Mr. Chair, may he answer that question?
I think he can speak to the volume if Mr. Rorie knows.
Could you restate your question?
And how many of those mediations have there been?
5 or 6.
Have any resulted in an easement?
Well, we're right there again, Mr. Taylor. I certainly can't answer that for you.
Mr. Chair, may he answer that?
Mr. Taylor, he really can't be speaking about the outcome of the mediations.
Okay. One final question. Last week I think you said if a landowner doesn't want to sign an easement, just says no, that they're not making a good faith effort to negotiate. So why does the landowner have an obligation to negotiate?
I didn't say it that way. If they were not visiting with us, I wouldn't say they aren't negotiating good faith. I would just simply say they're not negotiating.
Well, you said good faith last week.
Good faith was my obligation to continue good faith efforts to try to reach an agreement. I certainly wasn't talking about the landowners, talking about our folks.
Well, the record will speak for itself. So that's all the questions I have. Thank you.
Thank you, Mr. Taylor. Ms. Ryan, I think you're next if you still have questions.
I do. Thank you, Your Honor. Good morning, Mr. Rorie.
Good morning.
I'm going to try not to be repetitive. Friday feels like a long time ago right now, so I apologize in advance if I inadvertently cover some territory that's already covered. As an initial matter, I want to ask you about the easement payments. I think last week you talked about how most of them are in a lump sum form to the landowners. Is that correct?
Most of them are, yes.
Okay. And when landowners agree to a lump sum payment, is that payment paid 100% at the time of signing?
Most of the time, there are some scenarios in which the landowner asks for that to be split up a little bit. But what we would typically do is make a one-time payment all up front.
And you may also recall from Friday that we looked at an image of one of the parcels where the pipeline had been rerouted around a house because an owner built some hog confinement facilities. Do you recall that?
Yeah, went around, I guess the hog barn was put in the original proposed route.
Right. What would Summit do if on any of the, the parcels that are still, not under an easement agreement, what would Summit do if the landowners built additional facilities, since the last time you'd looked at that land?
Built additional facilities in the path of the proposed route?
Yes.
It's probably a question for council. I think that we would be in a spot where we probably would need to look at going around those, but that's also very rare. But I'm not in so I don't know exactly what the rules would be there. Certainly don't want to invite everybody to build things right there in that proposed route.
But they would have the right to do that before signing an easement.
You'd have to ask our lawyers about that. I don't know. I mean, we've certainly presented for a while, if they're not signed by now, we've presented for a while a proposed easement, certainly intentions, and we filed exhibits with the board, but I don't know the board rules or Iowa rules about that, so I'm just not equipped to answer that.
And I have some additional questions about the contact reports that Summit filed in July. You're familiar with those, I assume?
Are you referring to like the L4, L5, or L3, L4 testimony?
I think these are the ones that contain the lists of, I would probably have to look more closely at that. Give me a sec. These were filed on July 27th, and they are, per county. They list how many contacts, dates of contacts with the landowners and whether they're on phone or in person.
I recall that. Yes.
Okay. I just want to ask some questions about your procedures for maintaining those contact lists. Do you have a process in place to ensure that there are no duplicate listings of contacts on those lists?
It's pretty simple. We just don't duplicate. The only way that could happen is if a landowner owned multiple parcels. Maybe those were separated to where some of that contact could be duplicated, but we have a team of folks that spends a lot of time making sure that's rare, it doesn't happen at all.
And do you have a process in place for how something would get recorded if, for example, a landowner had been using a landline and they decided to disconnect that?
I'm not sure I understand if they could disconnected their landline and then got a cell phone or something like that, or just their landline went away.
Yeah, so say they disconnect their landline, the land agent calls, and the line's no longer in service. Do you have a process for noting that?
Well, we have a process for the attempted call. We also have a process for making sure that we're operating in real time and trying to figure out alternate numbers if they existed. I think if we went into a situation where a landowner didn't have phone access at all, that would be very rare. But if we called a landline that was disconnected, it would tell us it's disconnected typically. If it doesn't, and we're not getting a response from the landowner or able to engage with them, we're always looking at alternate methods to attempt to visit with them.
So if a land agent makes that call and gets the message that the phone line is disconnected, would land agents then stop calling that number?
If the phone line was disconnected, then well, they should. It's not a good use of their time.
What kind of process do you have to ensure that land agents aren't trying to communicate with people who are deceased?
I said again, that they aren't trying to communicate with.
Correct.
Help me there. Could you ask it again?
Ensuring that the people you are communicating with are actually alive.
Well, we run constant updates. They're not every hour. It's a lot of work and a lot of records to look through. But we update our title work. We try to keep in contact with landowners. In the unfortunate scenario that someone would pass away, we typically are able to be aware of that within weeks of that happening. If there was an obituary or death record or probate filed or something in the courthouse that would give us notice of that, it's certainly possible that someone would pass away unbeknownst to us, and we would continue to try to contact someone that was actually deceased for a matter of days. I would think that was the case, unless there was something very obvious that we picked up that would lead us to believe otherwise. It's just a function of this many folks and this many situations. Unfortunately, folks passing away is a small part of what we have to adjust around.
But once your land agents were aware that someone was deceased, then they would stop attempting to contact that person.
I think that they would certainly stop trying to attempt someone that was stop trying to attempt to reach someone that was deceased, assuming that it was proven or of notice that they were deceased. We would try to talk to the personal representative or what alternate person we would need to visit with.
What would be your process if someone requested that you stop contacting, for example, an elderly family member?
That gets very specific. Here's why. This is not the most fun part of my job. But when it comes to the law, if someone owns a property, we see very often that perhaps their age is higher than what you would typically see in a landowner. There may be children involved, other relatives, other interests involved. But legally, that person still owns the property and has a say over it to the extent that they're not incapacitated. We have to visit with those people because we have come across so many situations, I certainly have in my career, where relatives and other interests may have differing opinions than the person that controls the property, maybe trying to exacerbate a family situation that we don't want to insert ourselves into. So it's uncomfortable, certainly not very good optics, but it's part of my requirement to talk to the person that has control of the property unless they direct us to a different representative. In that case, we would obey them, or we should. But elderly folks that control their family ground control the direction of that easement, and I have to give them the same due respect and treatment and good faith effort as any of their relatives that may feel otherwise. That is not an uncommon situation. It's very common, and so we have to err on the side of what the law tells us to do.
And in that situation, if the property were owned by, say, a family trust, and there were other members of the family with sort of equal responsibility for the trust, would you reach out to the other family members?
We should talk to anybody that has interest in the property. But on the flip side of that, we would not exclude one particular trustee because they were elderly either.
Do you have a process for how to respond when someone requests that Summit make no further contact with them?
Yeah, I said again, I feel like it's the same question I just answered, but could you ask it again so make sure I understand correctly?
This case, instead of asking for somebody else, but if a person says for themselves, I'm the landowner, I don't want Summit to contact me anymore. What's your process for handling that?
Well, again, the first step is to figure out what's driving that. And typically folks share that with us. I'm trying to generalize on a wide variety of conversations, but we would try to find out why. And if that wasn't successful or we couldn't visit with the landowner anymore, we commit to try to keep them updated on how things are going with the project, to continue to have a seat at the table in terms of dialogue about the project.
So you would continue to try to communicate with them even if they have requested specifically no contact?
Objection. Asked and answered by several attorneys several times.
Okay. Ms. Ryan, can you get to your point or your question, please?
Sure. Do you make notes in your communication logs if someone requested no contact?
Yeah, I think we do, or something synonymous with that they're not interested or opposed or something like that.
You think, but you're not certain.
To the extent that I understand your question, I'm certain that we document to the extent that we follow instructions. We document whether or not someone was opposed or preferred not to be visited with at that time.
So just to clarify, you would document if someone was opposed, but you're not saying that you would document that they specifically requested no contact.
I think that we do document that. I don't have a process for it. Perhaps we're just speaking in a couple different synonyms here, but if a landowner said, I prefer not to be contacted, then we would typically write that down somewhere in our reports.
Would you then stop contacting that landowner?
It depends on why they didn't want to be contacted. We would certainly try to follow up with them and see if their mind had changed after a period of time. In so many instances, that's what happens.
So is that a no?
It's a circumstantial, hard to give you a yes or no there.
Do you have a process for noting when a landowner has told you to contact their attorney?
Yes.
That's all my questions. Thank you.
Thank you. Mr. Goodman?
Thank you. My name is Robert Goodwin. I represent Mary, Jamie, and Carmen Mosier, who own, rent, and farm ground in Palo Alto County, where the Summit Carbon intends to have its hazardous liquid pipeline. The land that they farm is actually 4 quarter sections in a row, so it's a total of 160 acres in a row, and the land is in a floodplain. I'll further represent to you that on March 7th of this year, the Palo Alto County Board of Supervisors voted to restrict Summit Carbon from putting in a pipeline in this floodplain. My question to you, do you have a concern about proceeding with putting in a pipeline in a floodplain and in an area where the Board of Supervisors has restricted your company from doing that?
Well, as far as the split concern there, I don't have a concern about the pipeline being in a floodplain. It's not my decision to put it there, but I've certainly operated pipes or worked on the operations side of pipelines and the installation side of pipelines that went through plenty of floodplains. So that's not a rare instance for me at all. So to answer your question, the first concern, as the land person, I have no concern about that. It would be up to our engineers to have more concerns than I would, but it's very common in certain parts of this country to be in a floodplain. The second part, as it relates to the restrictions of that county, I have very little to do with that. My opinion would be if it was reasonable to install a pipeline subject to certain ordinances, and it makes sense. But if it's not reasonable or overly restrictive or doesn't make sense, that's between our company and council and the county to figure out, not me.
I think you indicated that it is preferable to have the liquid hazardous pipeline not be in the floodplain.
I did not indicate that. What my statement was is it makes no difference to me one way or the other because it's very common.
I think maybe I misunderstood your statement that you thought would be better not to be in a floodplain.
No, sir, that's the opposite of what I stated. That you asked if I was concerned about it.
Yes.
And I'm not.
Okay. In reference to the Board of Supervisors restricting Summit Carbon proceeding in the floodplain, what is your company's procedure to address that issue?
I'm probably the wrong guy to speak to that. I don't deal with the counties at all. I don't collaborate on plans forward in that arena. I would be probably misspeaking if I answered that at all.
I'll also represent to you that on June 6th of this year, I filed on behalf of the Mosers what we entitled Inquiry Rate Rerouting Location of Hazardous Liquid Pipeline. We've had no response to that. I'll represent to you that the Mosers' concern is to move your proposed location of the hazardous pipeline out of the floodplain, which is on the north side of the Des Moines River, to the south side of the Des Moines River, which is not in the floodplain. And actually, one of the landowners is Palo Alto County, which does not oppose the pipeline. Is there a procedure in place where your company considers these requests to, in this situation, move the pipeline out of the floodplain and to the south side of the river where it's not in the floodplain?
Well, to answer your question, there is a procedure of assessing those. I don't design that procedure outside of land impacts as far as surface rights. I don't have any weight in that procedure. It's probably a better question to a decision maker much higher than me that would decide whether the county's preferences and the route of the pipeline are workable, and whether or not that transfers impacts onto neighboring landowners. It sounds like it would, but I'm not looking at it with you. That's something I would weigh in on to see, okay, what people are we affecting by this move? But the actual decision to move a pipeline is almost never mine.
Is there, in effect, a procedure to consider a request to, particularly for the Mosers?
Sure,
What is that procedure?
Well, it's not a process flow. It's just our engineers and project managers look at the request. If that request would involve different disciplines, whether it be environmental survey or there's a number of other disciplines that would possibly need to look at that, we all collaborate, and then a decision maker makes a decision.
As I said, we've had no response. Who is the contact person that we should contact in regard to this situation?
If you're talking about moving the pipeline, I think the best person to talk to would be Eric Skubinek. He testified earlier. Please don't ask me to spell his name. We can get it to you. He's our senior project director. He typically spearheads those procedures. And then if it needs to be elevated, it would go to Eric and my superior, which is Jimmy Powell.
How do I get in contact with him, or will he get in contact with me?
We can provide his contact information and hope you guys can talk about it. However you want to schedule that.
Okay. Hopefully you can get me the information.
Sure.
Okay. I have no further questions. Thank you.
Thank you.
Okay. Before we go to board questions, did I miss any of the parties? Okay. Crossed a lot of these out, Mr. Rorie, so looking for one that's not crossed out. Is there anything in Summit Carbon's easement which would prohibit development of a person's property as an industrial or commercial property?
Only to the extent that it would prohibit the permanent structures being placed within the boundaries of the easement and the workspace while it was in effect.
On page 7 of your direct testimony, we'll get that up, you discuss needing 4 pump stations in Iowa. Has Summit Carbon obtained all necessary land rights for those as it is requesting or is it requesting eminent domain over those areas?
We have one left, so we have 3 of the 4 secured.
Okay.
I'd have to ask council whether they're seeking anything eminent domain wise. We feel like we're in the finishing stages, right towards the end of getting that last one resolved. I expect that to be done in the next, I had to guess, 3-4 weeks.
Okay. Do you know which Exhibit H?
I don't have the H memorized. It would be the pump station in Clay County.
Okay.
It'd have a CL prefix there.
I think we can narrow that down. How many acres are the pump sites?
They vary a little bit in general, in between 4 and 6 acres, 4 or 5 acres.
Do the pump sites have different access requirements in the pipeline, and will they each have different driveway access requirements?
Yes, typically there's a permanent access road that goes directly to the pump station facility, and that's part of the transaction.
You state Summit Carbon will purchase the electricity from local providers. Does Summit Carbon anticipate generating some of its own electricity on site?
Not to my knowledge, but I'm probably not the guy to talk about that.
Who would be?
I think Mr. Powell would probably be the best guy to tell you whether they intend on generating their own electricity. I've not heard of that, but I just don't want to rule it out.
No problem. Thank you. Are you familiar with OCA Bent's Direct Exhibit 1?
I would probably need to be refreshed on it.
Okay, we can get that pulled up. So while they're pulling that up, we're going to be talking about electrical network upgrades. Okay. And I apologize if Mr. Chauvinek already answered this, or if we need to refer to him, let us know. Okay. Do we have that? Okay. I don't think we have a specific page number here. So OCA data response 66 states Summit Carbon will pay for the necessary electrical network upgrades. Do you know how many upgrades will need to happen?
I really have no idea. It's way outside of my scope.
So I suppose the locations are outside of the scope too.
Well, the locations for the power coming into sites I deal with, as far as working together with the utility providers and the landowners to get that worked out, as far as the rights to put the power in. Whether an upgrade is tied to that or how many of those locations, I couldn't tell you.
Okay. Will any new electric transmission lines need to be constructed or upgraded?
I'm not sure.
Okay.
There's a couple types of power involved here. I don't know if a transmission upgrade would be required.
Okay. Is that a question for Mr. Powell too?
I bet it is. I believe this is his data or his response to the data request, but Jimmy or Eric they would speak this language better than me.
Has Summit Carbon already begun the extension interconnection process with the relevant utilities?
I'm not sure.
Okay. Has Summit Carbon obtained all necessary land rights for the MLVs, or is it requesting the right of domain for those areas as well?
We're requesting the right for the ones that are remaining.
Do you know how many?
There's 23 remaining standalone valves. There are 4 launcher receiver sites.
Do you know the number of total valves? The total valves, outside of an ethanol facility, of course, 64 valves. 41 have been acquired. 23 we're working on. I might come back to that. We heard from several Exhibit H landowners in their recent testimony that they received a verbal offer from a Summit land agent, but then never received the written version of that offer. Can you help us understand that? Sure. So, don't want to cite specific people, but there has been an instance where there was a property that was not equitable to some others. The impacts were different. We reached an individual price for that impact. Whenever we consented to that, and it was the landowner's price, it wasn't a counteroffer, it was, yes sir, we'll pay that. The comment was then made, put it in writing, so I'm going to put it in the paper and make sure everybody gets paid what you just offered me. So those are not equal things at all in terms of what we were looking to do. It was a totally different arrangement, so we refrained from putting that offer in writing so that it didn't get advertised and create more problems than good. Can you explain how Summit Carbon has engaged the railroads to obtain crossing agreements? I can speak in generalities there. I don't manage that group. That's the turnkey group, and that I believe that falls under Mr. Skuvinek's scope. That's technically a non-environmental permit. I have a lot of experience dealing with railroads. I could tell you that they approach the applicable department at the railroad and start talking about either a license agreement or a crossing agreement. During your testimony, you stated Summit Carbon is requesting eminent domain for 892 parcels. Would Summit Carbon be willing to file an updated list containing the parcels still subject to Exhibit H? Sure. Okay. Thank you. That is the extent of my questions. Board Member Burns?
So I know it's been a few days. Remind me, were you on when a picture of a tire was presented?
I was.
Okay. So I had some notes here pertaining back to that moment. So I just want to be clear or clarify for the record, because there's lots of conversations taking place around this. If a farmer were to be doing normal farming operations, and I think Ms. Grunhagen talked about normal farming operations based on 352 of Iowa Code. If they're doing normal farming operations and were to hit the pipeline and cause damage, I believe you stated that is not on them, correct?
Yes.
So what if you have a contractor, a landowner, does not do a one call and were to hit the pipeline and cause damage? Who is responsible for the cost of that damage to the pipeline?
Well, I think it turns into a little bit more of a legal question there if they violated the one-call requirements. And then I admittedly don't know much about whether comparative fault is in play here, but I'd be speculating as to what direction that would go. We would encourage people to utilize one call and hire contractors that do. But I don't know if that would constitute negligence or gross negligence or something willful there. It's just not my scope. It is always encouraged that folks utilize the one-call system for that type of a reason as well.
And I believe there was a conversation, and maybe it was the one that asked this. Normal farming operations do or do not require a one call.
I think, depending on your definition of normal, if installing tile would require excavation, or if they had to do a one call for that, then that still might fall under the circle of normal. But if they're not excavating or doing anything that would be prompted under definitions of the one call requirements, and that's just normal farming.
I think that's all I have for clarification. Thank you.
Thank you. Summit, do you have redirect?
Very briefly, Your Honor. We actually have a hearing exhibit, and it was uploaded this morning. It's Summit Hearing Exhibit 1, if we could bring that up. And if I might have a staff member come down, we have the hard copies to be passed out.
Thank you.
Mr. Rorie, during your testimony over the last, I guess, Friday and today, you've been asked various questions about the voluntary easement template and referred to an Exhibit C. Is that right?
Yes,
Is this a representative example of what that Exhibit C looks like?
it is.
Nothing further, Your Honor.
Thank you.
I'm sorry. I'll move admission of this as Summit Hearing Exhibit 1.
Are there objections? Seeing none, the board will admit Summit Hearing Exhibit 1. I believe Mr. Jorde has questions.
Yes, thank you. So in regards to the exhibit that was just offered and admitted into evidence, you don't see the word normal or typical or farming activity anywhere mentioned or defined in there, do you?
No.
And in fact, your statements and related to that normal or regular farming activity can occur and no liability would be incurred by landowner are not actually stated or warranted anywhere in this Exhibit C or the voluntary agreement that you and I looked at, right?
It depends on how you define what's omitted there. I mean, you have the indemnification language that talks about anything other than gross negligence or willful misconduct, just stated. Normal farming practices would not constitute willful misconduct or negligence. So we could state normal farming practices or building a barbecue stand, and it would be the same thing. Unless it was grossly negligent or willful misconduct, they're indemnified.
And that's the whole point. It comes down to which lawyers are better at persuading or convincing what landowner activity that they might have thought was normal could maybe actually arguably fall under to a gross negligence or willful misconduct. You agree it comes down to the facts of the situation and analyzing each specific instance?
I mean, I think there are always facts involved, but you could look at further explanations in the 811 piece that was brought up last week, I believe by the Farm Bureau, talking about farming practices. I believe the board just mentioned that as well. But to answer your question, are facts involved with cases? Sure.
And because there's specific facts involved with each individual case, you are not able to state definitively here which quote-unquote normal farming practices may or may not lead to liability, because how we define normal could vary, correct?
I could state a lot of them, but it would be incorrect for me to state every hypothetical activity of a landowner that would fall under normal farming practices, but I can state quite a bit, certainly including the picture that the board just referenced about just farming over an easement.
And so you can, on behalf of Summit, therefore, bind the company with your testimony and warrant that if any farmer were driving a tractor, combine, or a piece of heavy equipment across the easement, it sunk, caused damage to the easement, and cost your company millions of dollars in shutdown time and lost productivity, that Summit would not, in any event, sue or seek any type of contribution from the landowner?
It's a really long question, but I will do my best here. I don't have the authority to bind us as it comes to specifics on indemnity. I think the law would. What I can say is if someone is conducting their normal activity, I don't see how that would constitute willful misconduct or gross negligence. Perhaps it calls for a legal conclusion, but my statement's also backed with quite a bit of experience with talking to landowners about their activity on top of a pipeline. And I can tell you, if you're running a combine, just like people run combines across the 300 plus miles of right of way that I helped operate in Iowa, that is normal.
And would it also be true, sir, that you, on behalf of Summit, cannot bind or warrant that your insurer, who may pay out an insured loss of lost productivity, lost profits, whatever the claim might be if a pipeline is damaged, that you can't guarantee that insurer, that insurance company, wouldn't independently go after a landowner to seek contribution?
I've never heard of that. You brought something up last week about that. I've never heard of that. Can't speak for the insurance company. They're talking about property damage or crop damage, and it probably would just come directly out of Summit. But if there was something beyond that and a claim needed to be made, I can't speak to how insurance companies behave.
Okay, thank you. Nothing further.
Thank you. Ms. Greenhagen?
Thank you, and I just have one follow-up question regarding Summit Hearing Exhibit 1 here.
Okay.
This list of 6 things, is this all that Summit typically negotiates with landowners, or can this be a much longer list of items?
It can be significantly longer. It's a case by case. This is just a generic form. So you see in paragraph 4 there it says insert approved terms on that. That's where any other specifics that are worked out with the landowner as it relates to their ground are cited.
Are there some typical provisions that landowners are requesting that are being included in this exhibit?
Some people ask a lot about abandonment, as you can tell. So we tend to recite exactly what I've testified to in the last couple of days, that if the pipeline is abandoned for a consecutive period of 5 years, etc., then it would be abandoned under CFR 195 in the board rules or Iowa law, sorry. So that's one example. Some folks ask specific things about tile, clarifications about rock removal. So many of these are already cited in our mitigation plan, but the landowners are more comfortable with it also being bound to the easement, and we're great with that, so we put it in there.
Would it include things like a trench plug to access other parts of the property, crop loss, pipeline depth, ingress, egress to the property? I mean, are there just a lot of different types of things that might be included?
There's a lot, but yes, everything you just cited is pretty common.
Thank you.
Thank you. And with no other questions, you may step down. Well, Summit, did you have anything to add?
No, thank you, Your Honor.
Okay, thank you. Now you may step down, Mr. Rorie. Okay, we are going to break, but before we do, let's just go ahead and bring Mr. Schmidt up. We'll get him sworn in, and then